Dr. Lalit Bhasin, Mr. Anurag Batra, Neena, Pramod ji, so many people present here today. It's indeed a great honor for me to be here with you, with young minds, young top legal minds who are the awardees for today, and share a little bit of my journey, a little bit of my experiences, and also speak on a particular subject, which of course I'll come a little later. Anurag talked about earning money. He also said that it's a byproduct, and I sincerely believe it's a byproduct. When we join this profession, this legal profession, and when I go to these law colleges and when I speak to these youngsters, I always tell them that the only way to succeed in litigation is to feel the problem of your client as your own. If you feel his problem, get into his problem, and then try to solve it, you are bound to succeed. And when I say feel his problem, I mean you sleep with the problem. Even when you are in the shower, you still have that problem in your mind. And many a times, you get an answer to the problem in one of the most unusual places. Not while you are reading the file. Not necessarily while you are reading the file. While you are thinking about the case. And if you actually sincerely believe in solving the problem of the client, then money actually is a byproduct. People who chase money, money runs a little ahead of you. You may ultimately get to it, but it's a little elusive. But if you look at the problem of the client and try to solve his problem, then money comes automatically. And I must tell you, I must share some a part of my journey, that in my initial years of practice, even clients who lost their cases, when I was a small junior lawyer in Supreme Court, sent me demand drafts 2 years, 3 years later in acknowledgement of what I felt for them and tried to help them. And that is what is all litigation about. And that is what is the byproduct which Anurag probably was joking about, but I think what he said jokingly was very, very relevant. I am a first-generation lawyer, and it will surprise a lot of you that while I was in first-year law, I got into a job. And I was selling steel. I was in marketing of steel for 9 years. 2 years I could do the law with the job. I could take leave, etc., and come and do my classes and clear my exams. 7 years I was thereafter, after passing my law from 83 to 90, I was only selling steel, not reading any law books, nothing, no contact. I was not in the law department of Steel Authority. I had a young friend when I was in school. His father was the Chief Justice of Patna High Court. That's the only exposure I had to the legal world. And as a young boy of probably 12 or 13 or maybe up to 15, 16, I always used to feel that this is where I should be. But I got into this job. My father said, law you can always do whenever you want to do. I got it very early. I was only 20 then. Because in Steel Authority you could apply at 20. So he said you can do your law simultaneously. You can decide to come back whenever you want. And I enjoyed the job also. I'll not say I didn't enjoy that job. But when they posted me to Assam, and then Calcutta, that suddenly I realized that I was not doing what I had planned to do. And my first ever visit to Tirupati in 89 of October, I still remember, I got the inspiration that I must resign. November of 89, I had some leave with me. I came to Delhi on leave. 6 months I worked in Supreme Court. I straight away came to Supreme Court. Until May, I realized that yes, I can get back into this profession. And June, I resigned, which was the vacation in Supreme Court. Got myself enrolled and told my senior that I have already resigned now, but I recall as a youngster when I tried my effort at elocution, school elocution, my feet used to shake. I don't know whether I'll be able to argue. I don't know whether I'll be able to, I've already resigned, I don't know what to do now. And the first day of Supreme Court after vacation, he gave me 3 cases to argue. And I had, I would say, a dream start. That as a young lawyer, and the confidence that he had in me was the 6 months that I worked with him, the kind of research I did for him. I remember he was doing the Kashi Vishwanath temple takeover case, and I used to go with him to brief Mr. P.P. Rao. He was the main senior engaged by him. And there was this Dashera vacations, and I was going to my village, native place in Bihar, North Bihar. So I went to my friend's home, that same friend, my childhood friend whose father was the Chief Justice. He was by then a lawyer. And I said, I want to read all these judgments on Article 25, 26, on the right to freedom of religion. And I must have carried at least 14 or 15 SCRs, each constitution bench judgment, each judgment into hundreds of pages, and took all of them to my village. And I read all of them, made notes of all of them. When I came back to Delhi, and when I went to brief the senior, and when my senior realized how well I was prepared, that is where his confidence in me developed. And it is that confidence, which gave him the assurance that I'll be able to argue. And rest, of course, God has been kind. That's all that I can say. God has been very, very kind to me. I've had my struggles. I had got only 80,000 rupees I got from Steel Authority as part of my contributory provident fund. I had just put in 9 years, so I didn't get any pension. That too, I bought the SCC books from that. Initial years were struggle. My father had retired. My LIC premiums I had to ask him to pay. I went for a couple of years to Tirupati. I've been going to Tirupati every year since then. Couple of years I went to Tirupati with I had 2 sons when I resigned, 2 small sons. Both are in this profession. And from Delhi to Chennai, I remember 2 years we went in 3-tier, all 4 of us. Then went to the bus stand and took a bus to Tirupati, and then, did the darshan and came back. But Tirupati, God, Balaji has been very kind. The subject chosen for me is a very touchy subject in today, which is the Collegium system. And in my address to on the Constitution Day, incidentally, I had also mentioned that there are lawyers in trial courts, there are lawyers in law firms, and I didn't know I'll be speaking very soon to a lot of you youngsters, mostly in law firms. who are not being considered for elevation. They highly deserve. Now, when you talk of the collegium system, the basis of taking over this function of saying that we will be the last arbiter of deciding who will be a judge was the rationale was that we as judges know the lawyers. And since we know the lawyers and we interact with them so intimately, so closely, we are the best to decide who should be elevated. Now, this premise is entirely fallacious. Although I personally feel that the collegium system is the right way forward, especially in a country like India, where most of our political parties are embroiled in very, very serious criminal and other cases, that no political party wants an independent judge. But unfortunately, they couldn't have said that in the judgment. The excuse they gave was that we know the lawyers. But what is happening is something which is not at all desirable. When they say we know the lawyers, they obviously mean their personal knowledge of the lawyers whom they know personally, and that to the 3 judges in the Collegium of the High Courts. What is the basis for them to know a particular lawyer? How do they know somebody so intimately that they feel confident that he'll be a good judge? Invariably, it is done on the basis of, it's saddening to say, but sometimes caste, sometimes relatives, sometimes juniors, and sometimes to oblige somebody. Very rarely you will find a collegium genuinely trying to find out good names. The other day I was having a chat with the CJI and Justice Kaul, and they say, yes, we also see lawyers in court and we realize that this lawyer can be a good judge. That again is a very wrong way to decide. Because the one who is arguing before him is not the target group for elevation. He is the target group for being considered for designation as seniorship, not for elevation. If he is successful as an arguing lawyer, his aspirations are entirely towards becoming a senior lawyer and going in that route. The real person who is most deserving is in a way invisible. The person who is doing the drafting. He probably, the ones who are good in drafting, who know good, whose knowledge of law is good, are the ones who would be most willing to become judges. And those are the faceless people in our system who nobody is wanting to notice. And that is in that context I mentioned the law firms. In that context I mentioned the trial court lawyers. The 3 judges of the Collegium may be having a particular roster. One may be doing PIL, the other may be doing tax, the third may be doing criminal law. But there are several other rosters. Some lawyers are good in several other fields. They never come before the Collegium. A person who is drafting well doesn't come and argue in front of the Collegium or the 3 judges of the Collegium. Why should he or she not be considered for elevation? In fact, I drafted a a bill to regulate the Collegium system. Thank you so much. A bill to regulate the Collegium system, and I gave it to Mr. Rijiju, the law minister. And in fact, he mentioned it in Parliament with my name. He said, Mr. Vikas Singh has suggested and given a bill to me. The idea was to bring in transparency. The idea was to ensure that all the eligible people of a particular category are considered. So the highlights of that bill, because I've done a lot of work on this, and this is a subject which really, touches my heart, and I'm so glad that business world has asked me to speak on that. So for instance, a collegium can decide that the age is 45 to 55. Now with this information technology, giving us all information at a press of a button, we can find out who all are there in that particular age group, whether it be in law firms, whether it be in trial courts, whether it be high court, or even of that state practicing in Supreme Court. Then you say at least he should have 10 reported judgments, again on fingertip. Different high courts can have a minimum income also. So for a Bombay High Court lawyer, probably income may be 50 lakhs or 1 crore or 5 crore, I don't know, whatever the collegium may decide. A Patna High Court may be probably 10 lakhs. Or Orissa may be 15 lakhs. So you say income above this level. Again on the fingertips. Now once you are able to identify this group of who all will fit these 3 or 4 essential parameters, then I have suggested that you should give these names to 2 eminent lawyers, and you decide which 2 eminent lawyers. The collegium decides which 2 eminent, and every high court, every court, Supreme Court, everywhere you've got eminent people. In Supreme Court, you can have people like Mr. Nariman, Fali Nariman, you can have people like Mr. Venugopal, people of impeccable integrity whom nobody will ever doubt. Ask them for their views. They are, or the Bar Association president. They, even if they don't know somebody personally, it is much easier for them to find out whether these names are, worthy of elevation or not. There is a very important integrity check which has to be seen, and any lawyer who's doing, who's into hanky-panky or whose integrity is not above board is known to everybody in the profession. All that screening can be done by some eminent lawyers, and then the names go to the collegium. So the collegium then applies its minds to all the names who fit the bill and then select. So there is an application of mind on all the names regardless of whether the collegium knows them personally or not. This whole business of the collegium knowing a particular person to consider him for elevation is completely unacceptable. This is where nepotism comes in. This is where the best are not being elevated. This is why the standards are going down. And I'll not name judges, but there are judges where, you feel you feel ashamed to argue because they don't know the basics of law. And judges who don't know the basics of law, and if there are 2 eminent senior advocates arguing on both sides, they just can't decide because they don't know what to decide. I mean, both sides are equally convincing. And hearing goes on and on. If you have a sharp judge, you can't, go on and on because he will know exactly, at least he'll know the basics, he'll know the fundas are clear. Most of these judges that are getting elevated don't have their fundamentals in place. Somebody asked me the other day that why are seniors given a certain amount of, preference, or I would say, why they are able to get the orders and juniors are not. At first blush, one would feel, really speaking, it should not matter. Anybody who speaks sense should get an order. But today, and I'll tell you from personal experience again without naming anybody, judges are afraid of asking a question in a brief to a senior because sometimes they feel that by asking this question, they will be shown in poor light of not knowing the law. And actually it is happening. Even the Chief Justice of India the other day mentioned on the Constitution Day in his speech, he said that especially in Supreme Court, that as lawyers we may have done a particular branch of law. In High Courts sometimes we do 3-4 more branches of law. Supreme Court we start doing everything. Several judges of Supreme Court have told me that there are several times a subject comes to us they have never dealt before. Never. You get the brief to read for the first time. This branch of law you have never dealt. Now a senior is well prepared because there are briefing juniors to him plus his own experiences, and normally people brief seniors only in subject which seniors are proficient in. So when the senior is standing in front of a judge who doesn't know the subject so well, he has difficulty in asking questions. So there is a notice and stay happening for a senior which may not have happened to a junior, which is unfortunate. And this is very unfortunate because anybody who is able to argue well or knows the subject should be able to get the same order, whether it be senior or junior. But this is happening because of the fall in standards of judges. And if this fall in standard is not to be addressed, then our democracy is in danger. Because the judiciary is the last place where a citizen of this country feels that his rights can be established. If he loses that confidence, or if he doesn't get justice, it really speaks volumes about the system, and that faith in the institution goes down. This is my third term as the President of the Supreme Court Bar. There are many things which I am privy of what is happening in the Supreme Court. I take it up with the judges in closed room. I take up all the issues. And as Lalit ji has said, Naina ji has been with me in the committee also last year. I don't mince words. Whether it be a problem of listing, whether it be, rampant corruption going on inside the registry. But when I have to speak in public, I have to be very careful. Because if I start saying what I talk to them inside the closed room in public, the faith of the people of this country in the institution will go down. And that is something which will be the worst thing to happen to the judicial dispensation system. Because even if some judges are corrupt, the general impression of the institution should remain intact. Corruption should be tackled. It's not that corruption should not be tackled. There should be in-house mechanism to do so. But the moment people lose faith in the institution, then justice will be delivered on the streets. Recently in this tussle, and I'm very happy to say that this Collegium recommendation being, kept on indefinitely by the court, by the government, is a matter of debate. It has been in the papers for the last couple of weeks, I would say. This matter also is being examined on the judicial side. And as President of the Bar, I am playing some kind of an amicus role in that. I am not representing any party. one judge, Justice Dipankar Datta from Bombay High Court, his name was pending for more than 2 months now, 2.5 months. And in the hearing on Thursday, if I'm not mistaken, or Friday, no, Thursday, I had suggested to the court that what the government is doing, that if you send, supposing, more names for elevation to the Supreme Court, they will notify the later one and keep the earlier one pending. And what happens with that, that firstly you demoralize that man. It happened with Justice K.M. Joseph. And secondly, you are able to make far junior people senior, and in judiciary seniority matters everything. So I suggested to the court on Thursday that please, by a judicial order, decide that the seniority will go by the date of recommendation and not by the date of notification. And judges framed a question on that. And I'm happy to say that because of that question being framed, that Justice Dipankar Datta has been notified today. Otherwise, there are 6 more vacancies in Supreme Court. If they had made more recommendations, one name would not be notified and the later names would be notified. And that's happening in the high courts as well. And this will have to be done if the collegium system has to survive. Firstly, they need to reinvent themselves. They need to go out of this mindset that they're supposed to know the lawyers. I've been struggling for Supreme Court lawyers to be elevated, and every time I get the stock answer, but they don't appear before the high courts. What to do? The collegium judges don't know them. Some lawyers even, take pro bono matters or sometimes go to the high court just to show their faces to the judges of the high court. From Supreme Court. Ultimately, the elevation of a Supreme Court lawyer only happens if the Chief Justice of India or one of the 4 judges, other judges of the Collegium who are in charge of elevation to the Supreme Court, make a call to the Chief Justice of the High Court. And that is something which is not acceptable to me. That completely erodes the transparency and the merit criteria. Anybody who's lobbying to become a judge, according to me, should be a disqualification. The only way you should be elevated is that you should have some kind of a search committee like the one I suggested, which I've suggested in my bill. And the search committee identifies the names and then let the collegium consider all of them and then make the recommendation. If it is only when this kind of transparency is brought in the system that we will have good people becoming judges. Because the sad part is that the best people who are most suited to be judges are not interested. Some are not interested because they are in that senior designation route. They don't want to become judges. They want to remain as arguing counsel and, make money, as Anurag says. But the ones who are drafting don't go in that league. Plus also they don't get into limelight. They are the ones who typically can be picked up for judges, because if you are good in drafting and if you have good knowledge of law and if you are good in integrity, you will invariably be a very good judge, because as a judge you don't have to argue, you have to listen to argument. And if you have to only listen to argument, the skills of arguing is not a skill set necessary for becoming a judge. And the moment the collegium system realizes this And I've been trying this for the last 3 years. I've been saying this in so many public platforms. I had the Chief Justices last year in Supreme Court. Justice Ramanna said that I want the Supreme Court bar to do a tea for them. I said, I'm not going to serve them tea, I'm going to have a proper speech. He said, but you don't, there is no convention of having a speech, it's just tea, that you serve them tea. I said, I'm sorry, not acceptable to me. So I put a dais and I had myself and the Chief Justice on the dais, and all the Chief Justices of the High Court were sitting in front. And this is exactly what I told them. I said, if a Supreme Court lawyer is judge material, then it is your responsibility to find out, because you have taken upon yourself the task of appointing judges. So you have taken a huge responsibility of ensuring that the best people are elevated. And where are the best people is your job. And if you are not doing your job, then you are not doing what you have taken to yourself as a solemn obligation of elevating the best people. So, I'm sure in this year's Chief Justices Conference, which just happened 3 days back, and I had a talk with Justice Kaul and Justice Chandrachud and some other judges. They have also, I believe, talked amongst the Chief Justices and taken this point of mine. But probably, if the government is unwilling to bring in a law, because the law that I'm suggesting ultimately is not palatable to the government also. Government doesn't want good people to come in. Government wants their own people to come in. They want control. They just want that I will decide. That's all. When the NJSC failed, NJSC had two elements. One was to decide who will be appointed a judge, and second was who will appoint them. NJSC failed only on the second part of who will appoint them. There was the first part of deciding the names or the people who would be forming that group of people who would be considered for elevation. There was no comment in the judgment, and that part of NJSC can be again brought back, but nobody is interested in doing that, because the government wants to appoint the people that it wants to appoint, and the Collegium says, no, I will appoint, I am the final arbiter, and we will appoint. But if there is some kind of I would say a hybrid, where government definitely should have a right to suggest who all can be. Anybody should have a right to suggest who would be a good person to be elevated. If that shortlisting is properly done, and the Collegium is made to look at all the names, I think we will achieve a great milestone in getting good people appointed as judges. Thank you so much.